What's up, everybody? Welcome back into another episode of the Lawyer You Know podcast. And last week was the final chapter in Donna Adelson's trial as she was sentenced by the judge. It was a pretty wild sentencing with all sorts of witness statements and letters and arguments made by the lawyers, some of which they felt offended the judge. And the judge ended up handing down a sentence that was not at all surprising. We got my take on it last week and so many other people's takes. But today, you get my dad's take, a lawyer in Florida for 50 years, state and federal prosecutor, and then obviously a criminal defense attorney for a very long time. So I've been doing this on both sides, handling sentencing hearings on both sides. And it was such a different and kind of strange sentencing hearing at times, just for it to have a very normal and the ending that you would expect from the judge. So why is it like that? So many questions for him that you guys sent in that we're going to be talking about on today's episode. So hit that like button and let's get to it. So as we were recording the podcast, news kind of broke that Joel from Surviving the Survivor has a comment from the Markells family about this exact sentencing that we are going to break down in today's podcast. But I thought it would be appropriate to start out with this comment from the Markells to see what they had to say and what we think of their comments here. So Joel said, Dan Markells' family releases a statement about Donna Adelson's sentencing hearing. During sentencing, our family listened in disbelief to the disrespectful and delusional statements made by both Donna and Harvey Adelson before Donna's sentencing for the first-degree M and other convictions of our son and brother, Dan Markells. Contrary to Donna's claims, she never mourned the loss of Danny's life, nor did she ever express concern for his sons losing their father. Testimony at her trial showed her callous indifference to his M, including written evidence that she dismissed the very idea that the boys could be sad or miss their dad. It is deeply unfortunate that Harvey used this time before the court to challenge our family's account of our relationship with Ben and Lincoln. We will set the record straight, as we have in court and elsewhere. Our family was cut off from contact with the boys for 6 full years. From the moment authorities implicated the Adelson family members in Danny's M until 1 hour after the Florida legislature passed the Markells Act. Since then, our interactions have been limited, mainly through Wendy's supervised Zoom calls and short visits. Wendy refuses to share their address, and gifts that we send must be mailed to her lawyer's office. We were uninvited to Benjamin's bar mitzvah following Charlie's arrest and never invited to Lincoln's. We grieve the years lost and the years ahead without independent and direct contact with them. Beyond her crimes, Donna scorned Danny, drove deliberate wedges between him and Wendy, and disparaged him to his own sons. Her display of emotion before the court was not remorse for Danny's death, but sorrow for the consequences she now faces for causing it. We thank the court, prosecutors, jurors, and law enforcement for their steadfast commitment to bringing justice to Donna Adelson and for her role in this terrible crime. What do you think about those comments?
Well, there's certainly no doubt that law enforcement has done a phenomenal job in this case and has worked very, very hard to bring justice for this family. So I like the fact that they did thank them at the end and didn't forget to thank them. As far as their outrage at the sentencing hearing, it's certainly understandable. I can see where they would be outraged by the claims of innocence. And the other thing that I found interesting too, I didn't realize it, but did you know they hadn't seen the children for 6 years?
Yeah, I mean, I knew that it had been a long time before they see them. I knew they'd been kept from them, and I know now, even though they do see them, it's not like normal visits with grandpa and grandma. And frankly, as long as Wendy is out and not indicted for anything, it's not going to be normal visits with grandma and grandpa. It's going to be supervised visits. It's going to be whatever Wendy says. It's going to be under Wendy's terms. And again, they can't even send them gifts because they can't know where she lives, which is really crazy to think they can't know where she lives. Right? Not the other way around. But, that's the world that they live in now, and it's brutal. And I think they have every right to be angry. They have every right to be frustrated with this. If it annoyed people in the public, what they were saying, especially Harvey and Donna, just imagine what the Markells were feeling. Luckily for them, they didn't have to be there to witness it in person, but I'm sure they've heard and watched it by now. And I don't know why they're in disbelief. I mean, frankly, this is par for the course for the Adelson family, for how they've been acting, for years and years and years while all this is going on. But I feel like this hits the nail on the head. It points out just the bizarre sentencing hearing that this was. She did not show any real remorse or take responsibility for what she did in order to even have a chance at getting the sentence lessened. And from my perspective, they're echoing the judge's sentiment with the sentence that he did end up giving, because it seems like prosecutors, law enforcement, the judges, the juries have all been in lockstep with the Markel family and how they see this case and getting justice for Dan Markel. And each defense attorney's arguments have not won the day when it came to the justice system.
But how sad is to get, you get justice, yes. But now, their son is gone. What they have left is two grandchildren. And how awful is it that you can't have a relationship with the two grandchildren that are left from your son? And it boggles my mind, and I really feel sorry for him.
Yeah, I honestly, I can't imagine what it is that they're going through. And then on top of all that, to have to deal with statements and comments like what were made at sentencing. Now, somebody fighting in a trial, I realize that's brutal. That's part of the system. That's something that, victims have to deal with. But then to continue it on through sentencing, it just, is throwing salt in the wounds basically at this point. All right, let's get to the rest of the podcast now. What's up, Dad? We are back talking Adelson yet again. I know we've done a couple podcasts on this topic already, and maybe this won't be the last, as so many people think. Maybe Harvey's next, maybe Wendy's next, but Donna, for now, is done as her sentence is in. And before we get to exactly what that is for anybody that hasn't already watched and seen what the sentence is, we will talk about it throughout. Most people know that she was convicted of the most serious crime you can in Florida that carries with it a mandatory life sentence. So why do we even have sentencing hearings in cases like this? So many people ask that exact question.
Okay. Well, it's a mandatory life sentence, and it's without parole.
Right.
So it really is life. But there was another crime. There are other crimes charged, like the conspiracy crime. And so those did not have a mandatory sentence. So the judge had discretion. Those could have been concurrent, which means it would run at the same time as their life sentence, or consecutive, which means that you'd have life plus 30 years, which is the conspiracy. And you may have a situation where, again, it's possible. Let's say the M case got reversed on appeal. Well, if the M case got reversed on appeal, then the only thing you'd have left is the conspiracy case, and the conspiracy case still had that 30 years. So it does matter to try to maybe lessen that 30 years in case there's an outcome that most of us probably don't expect.
Right. So as a defense attorney, when you go in and you've already lost, practically speaking, when it comes to the life sentence, what is your strategy as far as attacking the additional sentences and what feels like a quote unquote win for a defense attorney in a situation like this?
Well, number one, concurrent could have been a win, which means that time would run the same as the life sentence.
Which means,
Or
just for everybody that has trouble thinking about that, practically speaking, while you're serving your life sentence, you are also serving the 30 years. Or if there are multiple 30-year sentences, instead of 30 on top of 30, which is 60 years, it would be 30 concurrent with 30, meaning only 30 years, even if there are two 30-year sentences. That's the difference between concurrent and consecutive.
Right. Or instead of 30, you get 15, or you get 10 or 5, or probation. So anything less than 30 years consecutive would be a win.
And how do you get that? Like, how do you attack that in Florida as a lawyer in a case like this, where it's all the same set of facts, basically, and circumstances that she was convicted of, that get the life sentence? We talked about, and that's going to be kind of an overarching umbrella to everything we say, that if one day she was to get the M1 charge dropped or dismissed, or get a new trial on it and is not guilty on it, and that life sentence were to go away, that's what makes these arguments so important. But what are some of the ways that you can attack those additional 30-year sentences?
Well, first off, in Florida, we have sentencing guidelines. So you have to start with the sentencing guidelines. And in this case, sentencing guidelines are driven by points, certain levels. You get so many points for this, so many points for that, and it raises the minimum sentence that you can get. In this case, the argument was over what they call death points, which means you get, I think, 172.7 is the death points number that the state was trying to do. Without death points, it came to 82.5, and I believe that that's months that they're talking about. So they argued first whether the death points would count on the conspiracy. The judge ruled the death points would not count. And I don't think that was a surprise because I believe he ruled the same way in other cases when he did that sentencing,
Correct.
that the death points don't count for the conspiracy. So you could call that a win. So that the bottom of the guidelines, the lowest that Ms. Adelson could get is, I believe, 82.5 on the conspiracy case. So then you go to downward departures. Downward departures are reasons for departure, youthful offender, the fact that you've led a wonderful exemplary life. All sorts of things could go into it. And the judge in this case did say that he had the authority and that there were grounds if he so chose to use them for downward departures. So he agreed that there were some legitimate downward departure arguments in this case. In the end, he did not accept any of those, which is within his discretion not to accept any of the downward departures. But at least he ruled that they were eligible for downward departure.
How hard is it to win an appeal of a sentence when it's based on judicial discretion? Meaning, how hard is it to get an appellate court to look at what happened at sentencing and to say, oh, that judge abused his discretion by not granting a downward departure on this sentence?
In Florida, it's particularly hard because Florida is a little bit different. Let's just give you an example. In federal courts, they have a high end and a low end within a section. Florida doesn't have that. Florida has a low end, but no cap on the high end other than what the statute says the maximum sentence is. So as long as the judge does not exceed the statutory maximum, which again, a conspiracy would be 30 years, as long as the judge does not exceed that 30 years, then he has a presumption of correctness in that sentence. And it's almost impossible to reverse a sentence.
Right. But it does happen from time to time and it can happen. It's just extremely, extremely difficult, which means you make these arguments, you give this your best shot. Lawyers don't like to save things for appeal. You give this your best shot because you know the judge's discretion is usually where this case is going to end up. And that it's even harder. Would you say it's even harder to win that than a regular appeal of the trial?
Oh, absolutely.
Right.
Absolutely. You have so many more issues in a trial, things that are factual in nature, arguments that you made during trial. The discretion is not as wide, or at least is not, like I say, the parameters are different in trial than they are in sentencing. In sentencing, the parameter is the bottom of the guidelines, 82 point whatever, and the top of the statute, 30 years. As long as they're within that.
Yeah.
Trial is a different situation. Trial, you have all sorts of moving parts, and the appeal is you have a better chance in appealing your trial than you do anything else.
Yeah, it's like if you would have given her 35 years or 50 years or something like that, something crazy, then it's like, then that's actually an easier appeal sometimes than a trial appeal. But if they stay within that guideline, it's like, he's not going over the statutory max. That would be a problem. Then you might win that as a defense attorney. But generally speaking, doing what he did, it's very difficult for the defense to win that on appeal. So when we get to sentencing and we're trying to just basically win on the margins as a defense attorney, and this was basically just the defense's presentation because besides saying what they were asking for, the state didn't do much. And they already had the Markells make their victim impact statements when the trial ended right after the verdict, so they wouldn't have to come back down. They've done this, unfortunately, multiple times already, so they didn't want to put them through that again. So looking at it from the lens of a defense attorney, what are some ways and what can you really present to try and get that downward departure? You guys know I love simple staples when it comes to my wardrobe and what I wear. And comfort is key, but it also has to look good, right? That's the whole point of getting dressed up and going out into the world. And today's sponsor, True Classic, hits it out of the park. I'm wearing the shirt from True Classic right now. I'm wearing their jeans from True Classic, which has like a nice stretchy waist, which I always love and appreciate. And the shirts fit kind of nice where they should, and they give you a little extra room where you might want it as well. I've got t-shirts from their long sleeve shirts. I've got some of their kind of jogger pajama pants, kind of relaxation, athleisure stuff, and it is all incredibly comfortable. It's so much nicer than the cheapy stuff that you can like throw away, but it's so much less expensive than the really high end brands that just break the bank to buy for something simple like a t-shirt. And one of the coolest things about True Classic is, yes, You can head to trueclassic.com/LYK to find all of this, or it's even easier than that because True Classic is sold on Amazon, at Target, Costco, Sam's Club, basically everywhere you shop, right? So check it out. Let me know what pieces you get and how much you love True Classic.
Well, one of the things you try to do is you try to show what a wonderful person your client is. And the other thing you try to do is you try to not make the judge mad at you during the course of the sentencing. So you try to bring in all sorts of witnesses. I know they had some letters, but I've had cases where I've had 100 letters that they had somebody testify by Zoom, and then one person testified live who was also a witness at the trial. But I've had dozens of people testify, and sometimes a judge will say, "Look, I don't want to hear 50 people." So you'll have 50 people sitting in the back of the courtroom, and they'll all stand and say, "Judge, these are all people that are here to support my client, but we've chosen only 3 or 4 to actually speak to the court as a representative of these 50 people that are sitting there." And so it's got the trite phrase called the dog and pony show. And that's really what you're putting on. You're putting on a show for the judge to really show him that, there's a reason to depart down in a case. I mean, let's face it, in a case like an M case, that's a lot tougher to get the
Right.
sympathy of the judge on an M case. But these are the things you'll do in a lot of other types of cases where you really do have a lot more to work with.
Right. And would you say that it has had an effect on other cases and other sentences?
Oh, absolutely.
Yeah.
Absolutely. You hope that the judge has not made up their mind before that morning, because the judge reads a lot of stuff. They'll read the letters. In some cases, they read pre-sentence reports so that they have an idea of what they're going to sentence. They have an idea as to what the sentencing guidelines are. So when they come in there, they've got those things in their mind. The idea is to move them off the dime while they're sitting up there on the bench to show them, Judge, there are things you need to consider that you haven't considered. So that, and yes, it absolutely has had an impact.
Yeah, and I think it can be really important too, and it does matter in a lot of cases. Maybe not as much in this case, and especially the way that they presented it. But people were asking about: is there a limit to how many witnesses you can call and how many letters you can write? And generally, it's a reasonableness type of a factor. But I think you gave a pretty good example of how when we really want to show there's a lot. Again, you can have 100 letters, you can have 50 people there, but a judge is not usually going to let 50 people testify at a sentencing hearing. So you kind of pick and choose the people you think will present the best, or people that have different angles, maybe a family member, maybe somebody that they've helped out in their life, maybe a boss or an employee or somebody that can show their work
Right.
background, because you want to show this is character evidence. Another question people asked is a lot of this the same kind of witnesses or testimony you'd have at trial? And the answer is no, because this is something that's precluded from trial specifically because we don't want the jury to make decisions based off character. But this sentence, the judge is going to consider character evidence when making this decision. And you've talked a lot about downward departures. What are some of the things the judge can consider when going to the higher end of the guidelines, or like here when he ended up going with 30 years? What are some things that judges can consider as a negative factor for defendants?
Well, one is the chance for rehabilitation. The other is prior record. The other is remorse, which we talked
We'll
about
definitely get to that.
here. Yeah. The Another one is the fact that there were uncharged conduct. In other words, there were 50 thefts, let's say. This guy committed 50 frauds, but he really committed 100 frauds.
Mm-hmm.
But we only decided to charge 50, which the state does do sometimes. But during the sentencing, they'll bring in 100 people that this guy has cheated, even though they weren't charged as part of the crime. And the judge can take that type of thing into consideration.
Yeah, and that's always interesting, and that's kind of hard to parse out sometimes, and can feel unfair sometimes with how far that can stretch with what prosecutors can do. But when we talk about letters and witnesses, and that being a big part of it and can have an effect, how much prep do you do as a defense lawyer when when they reach out or your client reaches out? Usually we ask our clients, like, who do you have that would be a good character reference or witness for you? They'll tell us, what is your MO? What do you like to do if somebody's going to write a letter or somebody wants to testify? How much prep do you do as an attorney?
I work really hard on the sentencing. I prep every witness. I review every letter. There are I, I can't tell you how many times it happens almost in every case where I'll get the letter and I'll tell the person who wrote it, look, don't say this, don't say that, rewrite the letter so that it doesn't have this wording. One of the things I never want to have in a letter is that the client is innocent. That just,
Wow.
I know that drives a judge up a wall. So if a client, if someone writes a letter and says something like that, I'll call them and I'll say, look, take that sentence out. Or don't talk about this. Maybe there's something in there that's uncomfortable. So I review every letter and I amend every letter to make sure it reads the best it can before I submit it to the judge.
So what do you do if a witness says, no, I'm not going to write it unless I can say they're innocent because I believe they're innocent?
I well, with me, I control that courtroom. That is my job, and if that person won't listen to me, he's out.
Well,
And
you
I
you you
won't. I
confirm
won't.
with the client, you talk to the client, you tell the client
Right.
why, because that's the point is you don't have to submit every letter you get as a lawyer. You can get
Right.
100 letters, you can submit 50 with the client's approval, of course. So we talk to the client and you tell the client why this is a bad letter for us to submit. And if the client really pushes you to submit it, we'll talk about later when you come kind of at odds with clients when it comes to sentencing at certain points. But generally speaking, if a witness doesn't heed your advice as a lawyer, you don't have to submit that letter. And I think that's important when we get to some of the letters in this case and some of the testimony in this case. So you'll be very hands on in a letter. You won't tell them what to write
Right.
because it has to be from their point of view, but you will tell them to take certain things out, which is totally appropriate because there are certain things that are inappropriate for sentencing that they shouldn't put in there or that's going to hurt your client. And our goal is to help our client in sentencing, obviously.
I have kind of a form where I'll send them. I'll say, look, talk about these things. Number
Mm-hmm.
one, talk about how long you've known them. Talk about how you've known them. If you have some anecdotes of some particular instances with them that will exhibit their character, put the anecdotes in. So I give them kind of a guideline of what to write, and then when they give it back to me, that's when I do the amendments.
Right, right. So they kind of have and that was good because almost like a not a rubric, but so they're not just like writing 10 pages. It's like keep it to a paragraph or two about how great this person is, how long you've known them, what they've done for you, how they've affected your life, a character reference basically. It's not an opportunity to re-argue the facts, which we'll get to. So that's how you do the letters. What about witnesses? Somebody that's actually going to testify at the sentencing. How hands-on are you with that? What's the kind of plan for prepping their testimony?
It's very similar. If, let's say, there's 50 people and you've selected five that are going to be representative to actually speak, I'll ask those five people. In fact, I might do more than that. A lot of times I'll ask seven or eight, and then I'll pick the five right there at sensing that I want to put on. But those seven or eight, I'll ask them to write out what it is they want to say or give me an outline of what they want to say to the judge. Then I will look at the seven or eight and I'll pick the best five so that I have some ability to eliminate some of the people that I just don't think are going to present as well as some others would. And I'll pick the best ones after I read their outlines or their statements for them to get up there and speak. Again, and I will also massage those statements so that they don't have anything offensive in them.
Right. And you'll go over them with them before you put them on the stand. It's not the first time you're hearing the statement. Sometimes we even have people that wrote letters testify so we know kind of what they're going to say. And again, you can keep out the she's innocent or the arguments or things that might piss off a victim or a judge or even be attributed to the defendant to show lack of remorse if it's the defendant's husband or child or whatever, because some of those things can be held against the defendant. So very hands on. You know what somebody's going to say. You talk about what they're going to say. You don't have to put them on. Once they're on the stand and they say some wild stuff, sometimes you've got to adapt and deal with it or instruct them not to. But usually a lot of that prep and curation is done prior to the letter being submitted and prior to the witness taking the stand. Um, how often would you say it happens where clients looking at life or something really bad, or it seems like, lawyers are trying to win on the margins here, like we talked about getting a second 30-year sentence down to 15 when it's stacked on top of life? Like, how much does that matter? Lawyers still fight really hard to get that. But if a client wants to throw caution to the wind, they want to re-argue the facts, they want to say they're innocent, they want to pound the table, they want all their letters to say they're innocent, how do you deal with that?
Well, I've got to tell you, and you said that I've 50 years, thousands of clients. Never have I had a client not listen to me about what the right thing to do at his sentencing is. I've never had a client say, forget what you say, forget your advice. I'm going to get up there and say what I want to say. I've managed to convince the clients that those things are a mistake, that those things, if you say them, they can only go against you. So there's no reason to say it, especially if you go to trial, because you still have an appeal coming up. And so if you've gone to trial, you've got to be particularly careful about what you're going to say at sentencing. So I've never had a client that has not taken my advice and run with it the way I told them to do it. That's why, I know we're going to get into the individual facts of this. That's why this one I don't understand. But I've
Yeah,
never had a client that didn't rely on me.
and there's a way to say you're innocent or maintain your innocence in sentencing and not do it in a way that's going to hurt you, or do it in a way where you can still show some kind of remorse, or not say anything at all and make sure the judge knows it's because there's an appeal coming. And judges usually understand that. And while they might not give your client credit for showing remorse, they're not going to hit your client for lack of remorse. So there's two sides or multiple sides to all these stories and angles that you can possibly get to. As a prosecutor, have you seen? I'm sure you've seen clients throw caution to the wind and say all sorts of things, or defendants say all sorts of things in sentencing.
It never ceases to amaze me how stupid people can be.
Yeah,
And so, absolutely, these defendants get up there and, after, in fact, sometimes they even get up there after they've testified during their trial, and they'll get up there and say things that are totally opposite to what they testified to on the witness stand during the trial. I mean, that has happened to me, and I sit there, my jaw just drops, and I don't have to say anything because the judge tried the case,
yeah.
and the judge knows. Yeah, people can be really, really, really stupid, and that's why you hire a lawyer and you pay the lawyer, or you have a public defender. You should listen to that lawyer because he knows what he's doing. This may be your only time in court, but that guy's been in there 100 times, and he knows what he's talking about.
All right, so we'll get to this sentencing as an overarching question for these defense lawyers. What are some things you thought they did well?
That's a tough question. Um, I think that I think the whole sentencing was nothing like I would ever do, nothing like I would ever present it. Um, they when they said some good things, like some of the letters were actually pretty good and they were on point, but then those letters would get off point. Or some people would say some of the right things, and then they'd get off point as they kept talking. And the judge had to even interrupt people sometimes and tell them to stay on point as to why we were there for sentencing. Um, I I got to be honest with you. I don't think these. I was critical of these lawyers during the trial, and I know that. But I tell you, they didn't impress me at the sentencing. That's for sure.
All right, so then since you didn't give us a single thing, um,
I know.
I think that the argument that she was a minor participant was a good angle to take when trying to get the sentence to be reduced. When it came to the conspiracy. Now, I'm not talking about what was a winning argument or anything like that, but I think it was at least something the judge could have considered. And I think that there are some people in the world that may have thought, especially because they're calling Charlie the ringleader and Katie Mabanawa the ringleader, and somebody else pulled the trigger. I think that's a valid argument to make that she was a minor participant. It obviously didn't work, and I don't necessarily agree with the argument. And then I do think some of the witnesses they chose, like having a lawyer write a letter, I think was smart. Having that person that's a doctor and a state legislator, a former state legislator, was a good person to pick to make a statement. He had probably the worst statement of everybody at the entire sentencing, the state legislator, which we'll get to. But I'm saying if you're going to have people come and speak on behalf of your client, those types of backgrounds and resumes, I think are good people to pick. So if I'm trying to find some things they did well, I think they maybe picked some arguments that could have been winning arguments and some witnesses that could have been very credible as witnesses at sentencing. Building building routines and habits that help you feel great can make such a difference with how productive you are throughout the day, which is one of the most important things to me. I have to be productive. And one of the habits that's really changed my outlook on the entire day is if I start the day with AG1. I feel better, everything's more consistent, and it makes me feel like I'm starting the day on the right foot health wise, which is important with all the decisions I'm going to make with what I eat and drink and sleep and work out and whatever it is throughout the day. I love starting it with the greens from AG1. And if you're a fan of AG1 as the product or the brand, and they're a sponsor of the show, so you know I am, they also have a new product called AGZ. And if you couldn't have guessed it from the title, the Z represents their nightly drink that helps you wind down and rest up. It's a melatonin-free formula with clinically studied herbs, adaptogens, and minerals. I'm still waiting for my AGZ in the mail, so I can't wait to try it. But it also, just if you look at the ingredients, is a great source of magnesium, which can have a lot of other health benefits besides helping you wind down at night. So if you're ready to turn down the stress and focus on the rest, head to drinkag1.com/LYK to get a free frother with your first purchase of AGZ. That's drinkag1.com/LYK.
Well, you're right. You pick a former state legislator who, I mean, on its face, here's a guy who helped write the sentencing guidelines, and
Right.
here's a guy that dealt the Judiciary Committee. I think he was vice chairman or chairman
Yep.
or something. I mean, he had the right credentials, but you didn't prepare him. You didn't control him, so he was out of control when he spoke. So I can't. Yeah, you pick the right guy, but he makes the wrong
I
presentation.
get it, but that's why my question
Yeah.
was, what do you think they did well? Obviously, they lost. Obviously, it didn't work. Obviously, the judge didn't buy it. Obviously, most of the world didn't buy it. But I'm saying if we're trying to look as lawyers at something that was a positive that came from this, that's what I took from it as at least a positive that I think, okay, those were some good decisions. It all ended up falling flat because of the execution, but I think some of the plan was there.
Well, they also compared sentences like Rivera
Yeah,
sentence, 19 years. I mean,
I
those
thought
are
that was
things
good
you
too.
should do.
Yeah,
Excuse me.
I thought that
Yeah,
was good too.
yeah, those are things you should do. They talked about Garcia, the sentence Garcia got, and is it right that she gets the same sentence Garcia gets,
Mhm.
since Garcia apparently was the trigger man.
Right.
So they looked at that, and then they threw Charlie under the bus, saying, Charlie obviously is the mastermind.
Mhm.
So how could she be the mastermind? How can you have two masterminds? So you got Charlie. Uh, so
Yes,
I,
good
yeah,
job. I'm so
they
proud of you
did.
that you were able to find at least like something positive to say. I know it's not easy. I'm not saying they did a great job. I want to start with the positives because my next question is going to be, what do you think they didn't do well in the sentencing, which I'm sure you're going to have a lot more to say now. So now we can get to the negatives. Where were the mishaps? Where were the mistakes? Where did they really mess up this sentencing? Because there were plenty of things that just is not how a sentencing is supposed to go with how this one went.
Well, number one, a common theme in what they presented was that she was innocent. And they had multiple people say she was innocent. I'll talk more about Mr. Edelson because I think he is
Yeah.
particularly is worth mentioning. But you had these other people that would say things, like she was exploited, she was used, she was. And this is the guy on Zoom,
Yeah.
exploited,
This is the state legislator. Yeah. The
yeah,
former state legislator.
used, innocent. Um, he mentioned the Holocaust. He mentioned the fact that he was on the Judiciary Committee. He mentioned that about sentencing articles, and I mean all sorts of stuff. But a guy in the Judiciary Committee at the legislature who's writing sentencing guidelines, he's not. He shouldn't be standing up there saying, basically, the guidelines don't work, and if someone's convicted, he shouldn't have to use I mean, it just doesn't make sense that he was up there doing that the way he
He
was
even
talking.
went a step further that was worse that said, I know the purpose behind the rules and laws. And we as lawyers, like, this, Dad, we love to use that. If we have, the committee notes or what was the spirit behind this rule, we will argue that till the cows come home. But he basically said the spirit behind the rule is nobody should get what the sentencing guideline is. And it's like,
Yeah,
I know more than you, judge, so you should listen to me and I should sentence her because I'm an expert on sentencing. which the judge did not like. Anytime a judge says, isn't he supposed to be a character witness? He's not an expert on sentencing. That's not a good thing for a lawyer.
And if they had prepped him properly, he could have been good.
I
And,
agree.
he had credibility. He had experience that could be used as credible. If he'd have just wrote his script out, and if they had approved it, again, I hope they didn't approve the one he'd said. But if they approved a good script, he could have given a good presentation. He had the background to do that. But instead, he went off on this exploited, used, and innocent tangent, which no judge is going to listen to, and no judge likes.
And it's literally, he could have been like, I was a former state legislator. I wrote the sentencing rules. I was on the judiciary committee, and this is not how sentencing is supposed to go. She is not supposed to get the same sentence as the trigger man. We are not supposed to give people that were more intimately involved lesser sentences than her. That's not the spirit of the rule. She was a minor participant in this. She was dragged into it by Charlie. She didn't even know she was dragged into it. Such a minor participant. She should get a lesser sentence. Something like that, which is tied into what the lawyer's argument is, because guess what? This isn't a surprise. This is all something that's prepped and planned. The lawyer knew what her argument was going to be. She should know what the witness statement's going to be. It should all marry together so that she has record evidence to support her argument that this is a reason why Donna should get a lesser sentence.
He could have said, and again, the way you said it, he could have said, look, she's guilty. She needs to be sentenced. There are guidelines for the sentence, but the guidelines also provide, and I know because I wrote them, I know their intent, that everybody shouldn't get the same sentence, that there should be some adjustments for their role in the offense. He could have done stuff like that instead of arguing innocence. I mean, that was anyway. So he lost everything once he finished talking. He was done, and I think he had no impact on the judge whatsoever.
I think he was the first witness. I'm not positive, but I feel like it was such a horrible start with him that it just kind of went downhill. We can talk about any of the other witnesses you want. If you want to get to Harvey Adelson now, we can. But if you want to talk about any of the other minor,
Well, I'm just going to briefly say that I call him the travel guy. I forget his name, but the travel guy, he talked about it was an unfair county. He couldn't get a fair trial, and apparently the judge said he wasn't annoyed by the fact that he said things like that. And then she read the letters.
well, hold on,
There
before
was
we get to
no.
the letters,
Go
the
ahead.
travel guy, and there was multiple discussions, including Harvey Adelson, about the change of venue and how unfair it was in Tallahassee, how this judge basically made a mistake. And again, although the judge said he wasn't bothered by it, he made another comment like, are we going to rehash pretrial rulings now? Like, what are we doing? And all of those not so subtle comments were aimed at the defense lawyers. Like, what are you guys doing? Like, did you not prep these witnesses? This is not what is appropriate here. You are wasting the court's time and not helping your client, which is what you're supposed to be doing. Like, how often does a judge pipe in at sentencing? And if they do, like, and this is the feedback you're getting, what are you thinking as a defense lawyer?
Well, keep in mind, and it wasn't really mentioned at the sentencing. There was a motion for new trial filed. All of these issues were raised in the motion for new trial, and the court already had denied it before the sentencing. So the defense had already argued these issues.
Right.
The judge had already ruled on these issues, and he saw no reason to hear them again after he'd already ruled on them and they'd been raised. So it was ridiculous that the defense lawyers let this happen after their motion, based on all these same things, had been denied.
Yeah. And
So,
that's just not what you want. Because again, as lawyers, and why people kind of think it's stupid or a waste of time, or why do we even do this? It doesn't matter. Like, there's so many motions we file, arguments we make where like lay people would think that this is one of them. It's like, she's going to prison for life. Why does this matter? Why are they even fighting about this? We've talked about the reasons why you do it. But as a lawyer, this is also where you just ignore things that you've argued in the past and that you will argue again in the appeal. You just ignore them. You erase them. This is not the time to argue change of venue. This is not the time to argue that, this witness should have been able to testify, or that witness you just forget those as if they don't exist. and you focus on the key arguments you can make to affect the sentence at sentencing. That's what you have to do as a lawyer, regardless of what the media says, regardless of what anybody else says, because the lawyers and the judges, and more importantly, the appellate court, they understand what we are doing as lawyers and why we are focusing on certain things, regardless if, some mainstream media or court TV or somebody with a podcast looks and is like, oh, this lawyer didn't even say she was innocent. Her own lawyer doesn't think she's innocent because they're not arguing that at sentencing. They don't understand how sentencing works. And that's why you really just don't, you abandon that argument in sentencing, because now the task at hand, it's like winning the battle. You've already lost the war, but win this battle here, get her a lesser sentence, and then you move on to the appeal.
Plus, it's important to concentrate on the important things. If you
Exactly.
water down your arguments, if you've got 5 good arguments, but you throw 50 out there, how's the judge going to know which one are your 5 good arguments? So you're water down your argument by throwing all this stuff out there. Focus on what you should be focusing on.
Yeah.
The letters, reading the letters and not reading the letters, sometimes, it's the judge has all the letters. The
I,
judge,
I
my guess,
felt
has read all the letters.
I felt like that was high profile. Cameras are there, microphones are there. You have the opportunity to make your client look good. From my perspective, that was probably more for the cameras, but regardless, that's
Could
fine.
be.
I've
Yeah,
read a
that's
letter
no big.
before, so it's not like we've never done that. But generally, the court reads the letters.
Right. And then Harvey.
Yeah. Did he seem like a
Then,
guy that was scared of getting charged right there, then and there?
he looked at me like he seemed to me to be angry. I mean,
Very.
yeah, I mean, he seemed like he was mad. Um, I wrote a couple of statements here that she's done nothing wrong. People outright lies, biased judge and jury, and then the judge does eventually interrupt him and tell him to, stick with what he's supposed to do. And then the judge, I can't remember if the judge instructed but the judge, I think, instructed the defense lawyers to go up there and amend his statement so that he doesn't say any more of these ridiculous things. So in the middle of a sentencing hearing, that's when these lawyers are amending the statements that are being read to the judge. I mean, that's the time to do it, not beforehand. So that's what they actually went up and actually did that. Um, and then he talked about vengeance and this is wrong. I mean, everything he said was almost totally improper. There was nothing worthwhile in what he said. And then we go to, unless you
Well,
want to say
hold
anything
on,
more
real
about
quick.
Harvey. Yeah, yeah.
So having somebody whose name was mentioned throughout the trial, who might be a co-conspirator, who everybody knows might be next, or something the state might be considering, what are the dangers of having somebody like that speak at sentencing?
Well, the dangers are that he's going to say something they're going to be able to use against him if they indict him or they try him or charge him. So if he is charged, even if he doesn't testify, these things may still be able to be used against him because there was a court reporter there and they took everything down that he said. And it doesn't have to be under oath or anything. The fact that he said it, and the fact that there's a record of it, it could be used against him. I don't know if he has a lawyer or not, but his personal lawyer representing his interests. But if he has somebody representing his interests, that guy should have been there and should have gone over this statement and made it as supportive of the wife as possible without getting into the facts of the case.
Right. It could have been a lot more innocuous than it was, because I mean, he came out swinging. He said all sorts of things about the judge. So like if one day, I mean, frankly, I'd probably file a motion to recuse this judge if Harvey Adelson ended up in his courtroom, since in fact, under oath, he said for the world to see that this is a biased judge and he should have changed the venue and all this stuff. Now, would it work? Who knows? But I mean, he went at the judge, did not seem like somebody that was scared of getting arrested. Still seems like there's still like a piece of me that every time I see Donna and Harvey or hear them say anything, they're surprised that this is happening to them, which maybe some people could argue is them maintaining their innocence and they really don't think they did anything wrong, or just they don't get it. It's not clocking with them. But there was an element of that to me as well.
Yeah. Again, he just downright angry. And I think that from what we've seen, he's probably the least likely to get charged. Though, I mean, just honestly, we haven't really seen a lot of direct involvement, at least the facts that we've heard.
Mm-hmm. All right. What else stuck out? I want to get to Donna's statement as well, but is there
Yeah,
anything else?
that's it for Harvey.
Okay. What else?
And Donna.
All right. So what are some of the considerations about whether or not you even want your client to make a statement?
Well, first off, she didn't testify at the trial. So, you don't have her saying anything at trial, but then she chooses to testify at her sentencing, basically testify at her sentencing. And she says things like, I swear that I did that. And yet she didn't want to be placed under oath
I know.
at her sentencing so that what she said would be under oath. It started off, I think, pretty rocky, and never in a million years would I have let a client do this. And I've never, honestly, I don't think I've ever seen a defense lawyer let a client do what she did at this sentencing. I've just never seen a good defense lawyer do that.
I mean, I've definitely seen defendants do exactly what she did and say they're innocent and point the finger and pound the table. I don't necessarily know all the lawyers personally that have had their clients do that, but it's not really that abnormal of a thing for the client to maybe say I'm innocent or to do some of this wild stuff. It's more abnormal for all of the other witnesses to do that. From my perspective, that was the big miss from the lawyers is maybe the client's a little out of control at this point and she feels like she's not got nothing to lose and she's not taking your advice, but all the witnesses having the same theme, like to me, there's really no other explanation than the lawyers felt like that was okay or felt like that was going to be the way they wanted to handle the sentencing. And that was the real big swing and miss from my perspective. And even though this is another question people had, even though it wasn't quote unquote under oath, her statements can still be used against her. If let's say she wins her appeal and there's another trial, anything she said there can be used against her still.
She did more than just say she's innocent.
I
I mean,
agree.
she did a lot more than that because I don't know. I went back just for the heck of it and listened to Charlie's sentencing.
Okay.
And at Charlie's sentencing, they presented almost nothing. And all Charlie said was, I still maintain my innocence. That's it. And that's the right thing to do. If you're going to say something, that's the right thing to do. But she went way beyond that. She goes on to say she's innocent. There was no evidence. She had no knowledge. The Tallahassee jury was biased. The jury was sleeping. Um,
Yeah,
uh,
that was
you, you
it was
know,
like it was literally like a circus. It was like there was no rules. There the wheels were off the bus. There was no rhyme or reason to half of it. It just made no sense. It seemed like it was a Donna Adelson planned and prepared sentencing.
yeah,
It did not seem like anyone other than Donna Adelson was driving that train, which again is bad for her when she's trying to say, I don't control any of this. I'm a small part of this conspiracy. I didn't know what was going on. I'm not a matriarch. I'm not a mastermind. When it really seemed like, even more than the lawyers, that she was controlling exactly what happened in sentencing.
yeah, yeah. It's. I think that if the lawyers tried, they were just unsuccessful in
Yeah,
trying to control her and what she was going to say.
right.
I mean, look at the way she was about whether she was going to testify or not. I remember we all watched that and we all, she thought about it for days and she still had trouble making up her mind. But she sure had no trouble speaking at the sentencing because she assumed that the prosecutors weren't going to cross examine her. So she could say anything she wanted and get it all off her chest and just rip everybody and blame everybody for the fact that she got convicted except for herself.
Yeah. And did you see one of the other motions I read where the judge actually went back the next morning and asked them if they wanted to reopen their case to call her to testify, that he would allow them to after he went home that night and did extra research after basically saying, you got to decide here and now, there might be sanctions, whatever. And that was one of the things I was like, man, I think that was a mistake. Well, at sidebar, which we didn't get to hear, he told them basically, I did some research. I read the case law. If you want me to let you reopen your case, even though you rested to call your client, I will let you. And then once again, they had another colloquy where she said no, but he did kind of change his tune with that whole
Oh, I
debacle that
didn't see
happened
that.
near the end. Yeah, it was very interesting. And I thought a really good job by the judge. Some judges would not have done that. They wouldn't have had the humility to do that, even if they did think it was the right thing. So I give him a lot of props for going and doing his own research and then coming back and doing the right thing because above him feeling like he's right or feeling like he's king of the castle or the smartest guy in the courtroom. He wants a fair trial. He wants to protect the record for appeal, which is all you can really ask for in a judge, frankly.
Oh yeah, yeah.
What did you think of
Um,
the lawyer arguments?
you mean things like minor role and
Well,
those kind
the
of?
arguments that I mean, she did basically re-argue a lot of the facts and how Don Adelson wasn't involved, didn't know all this stuff, but she did connect at least some of it to, yeah, minor role and the worse contributors got the same sentence or lesser sentence than the state's asking for from Donna. Anything stick out about Fulford's arguments?
No, but she did do the right arguments. When you asked me before about what they did right, her argument was all right. I mean, she did the right argument. She didn't stray too far like the other people did and claim she was innocent during her argument. So her actual arguments, she stuck to what she should have stuck to when trying to talk to the judge and trying to get the judge to do a downward departure. Uh, the problem was everything else that happened in that sentencing hearing.
Yeah.
But her statements, her brief statements, she covered it pretty well.
Yeah, I thought she was just okay. I thought she picked the right arguments, but
Right.
a lot of what she argued was just like going around in circles and rehashing evidence that had already been decided that you're going to know the judge disagreed with. And then again, putting your foot in your mouth saying, I know the judge probably didn't like some of it. He's like, I wasn't bothered by any of it or whatever. She made it basically made it sound like you probably took it personally, judge. And he's like, no, I didn't take it personally. She's a former judge, by the way. I didn't know who she was. I don't know if you do.
No.
But she was a former judge, by the way, which, adds a whole level of interest to how she argued and how she dealt with the judge kind of throughout the trial. But okay, so she makes her arguments. State doesn't have much to say. Judge ends up giving the sentence and tacks the 30 years on top of the life sentence. What did you think about the sentence?
Well, I thought frankly that sentence didn't surprise me.
Me neither.
It was consistent with what Charlie got, and he said that the evidence was clear. I mean, I know he made some statements like that,
Yeah,
um, and
that
he
she
did
was
not
a.
believe
That
she had a
and he
minor
even said,
role.
yeah, he even said she was not a minor role. Like she had a major role in the conspiracy.
Right. So, and he's, again, like I said in the beginning, he said that he could depart downward, but he's not going to. And he, gave her that sentence. Again, consistent with Charlie. Uh, and if you believe she is guilty, and the jury did say she was guilty, this is a heinous crime. All the planning that went into it, all of that, and all the motive for the murder, all that is pretty aggravating. So I think the judge gave her the sentence that doesn't surprise me and was consistent with what he's done. Otherwise, this judge, though, in all honesty, has been very level in how he's been doing the trial. So I don't. They're going to have a tough time saying about his bias and prejudice. He's been very calm through the whole thing and hasn't really yelled and pounded his fist and like we know a lot of judges would do during this. He did a very good job of keeping this trial under control. Another thing that I'm sure didn't escape him, aside from the lack of remorse, which is part of this, is this woman refused to testify during her case chief to defend herself and to be subject to cross examination, to say all the things she said at the sentencing. I'm innocent. I had no knowledge. All those things are all legitimate testimony that she would have given at a trial if she'd have testified. And I'm sure it didn't escape the judge that, she claimed her Fifth Amendment rights so that she wouldn't be subject to cross examination and didn't bring all this up at trial. And that's an important point, I think.
And so he's not going to consider it as record evidence or as facts because it's not on the record. She had a chance to put
Right,
it on the record and she didn't. And sentencing is not your opportunity to testify about what happened as a defendant, but that's exactly what she tried to do.
right.
Kind of the last interesting thing that I remember from sentencing is they seem to be in agreement that they don't want her to be in the same jail as Catherine McBanawa for a bunch of reasons, but especially for Donna's safety. And then they asked for her to be in a prison closer to South Florida so her elderly husband, Harvey Adelson, can make the trek up to see her. How does that work? Figuring out what prison they go to, how much control does a judge have over it? How much control can you have as a defense lawyer on trying to get your client somewhere that's convenient, especially when we're talking about prison for the rest of her life?
Well, a couple things come into play. Number one, the Department of Corrections tries to put people close to their family because they understand about visitation. So if they can, they do it. Number one. Number two, a judge's recommendation is influential but not binding. Prison is an executive function. We have three branches of government: executive, judicial, and legislative. Prison is an executive. It's the governor's function, basically, executive. So the judge cannot tell an executive how to run their prisons, but they do try to give a judge deference when they do make a recommendation. The other is bed space. If there is no bed, then she's not going. So that's another problem. And then another problem she has is level of security. Because she has a life without parole as an M convicted, obviously she is a violent offender, a very violent offender. As a violent offender, there's only so many women's prisons in Florida that do violent offenders. So she's got a limited number of prisons. She's got bed space issues. But on the other hand, the judge recommended it and they try to put it close to the family. So, you really never know what's going to happen. She will probably be classified while she's in the jail in Tallahassee because they have traveling classification teams now, especially for women, because they don't have a women's classification area yet. So they'll send a team up there to interview her and decide where she should go in the system. Again, seriousness of the offense puts her limits the number of facilities she can go to. Like she's not going to a camp or she's not going to a low-level facility.
Yeah. Yeah. I think that it would be nice if they could get her as close to South Florida as they can, but it's also not really the most important thing in our judicial system that people are really caring about, I guess, which I can understand, but I think it's appropriate to try and do that as much as you can in the situations where you can, but there's only so much you can do to really control it. Anything else on the Don Adelson's case or her sentencing that we haven't talked about yet you want to mention?
No, I think that was just one of the most bizarre sentencings. Really, I've rarely seen a sentencing like that. That
And you mean
talks
because
about
of
people are innocent.
Sorry, go ahead. Explain what you mean by that.
Arguing innocence after a jury has found you guilty and you're there for sentencing. I just have rarely ever seen somebody say, not again, maintain innocence is different. I maintain my innocence because I'm appealing it. I got to be fine. That's what Charlie said, and that's appropriate and that's the right thing to say. But to sit there and tell the judge why you're innocent because he's biased and because the jury's biased and because people lie and da 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 da, that's really something. That's something I rarely have ever seen in my career.
Yeah. It was definitely weird and ineffective. Like that's not going to get it done for her. It's not going to help her with this judge. And in fact, it didn't. So that's the end of the Don Adelson saga, at least for now. I'm sure there is going to be an appeal. We'll see who she gets as her appellate lawyer. And of course, we will wait and see if anybody else in the Adelson family or beyond is connected to this and charged.
Wouldn't you hate to be Wendy? I mean, I would hate to be Wendy sitting around my house. I'm the last surviving parent of my two children and sitting around waiting. Am I going to be indicted for M? That's a heck of a thing to live with.
Well, I'd hate to be the Markells whose son was killed and taken from them. I'd hate to be
Yes.
Dan Markell's sons who have to live with all of this swirling around as they get older. They're just going to know more and more about this. That's absolutely brutal. But yeah, to be Wendy and Harvey in this situation is not great either. I don't know how they sleep at night. I'd be nervous every single night when I went to bed, potentially that I'm next, and maybe she will be. So we'll keep an eye on it. Thank you guys so much for coming, hanging out with us and listening to it. Make sure you put any questions you have in the comment section if you're watching on YouTube. Feel free to leave a review, leave a like, make sure you're subscribed to whatever platform you're listening on. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.